Good morning, good afternoon, everyone, depending on where you're joining our Fieldfisher team from today. Welcome to Fieldfisher Silicon Valley's latest webinar. We're talking today about the Digital Services Act and the Digital Markets Act and what you need to know. I'm joined today by Andrea Ortega, Richard Lawn, and Annie McLaughlin, all working out here in Silicon Valley with us and hopefully offering our UK and European perspective to all that we're about to share. I am Mark Webber, the US Managing Partner of the office out here, and we're here today just to dive into something which, to be honest, having conversations with clients out there is actually quite confusing, in part because a number that we work with are deeply bedded and saturated in the world of privacy, and then suddenly are being hit with laws which don't necessarily make sense in the world of privacy. This is a wider set of legal discussions to some that we've had in recent sort of months. But we're really sitting and bumping against the EU's digital agenda. Part of EU harmonization policy, so there's going to be some consistency EU member state to member state, although as you'll come to learn, some local market definition and departures from that EU consistency. And then of course the UK post-Brexit, sitting outside of those member states, will have some similar issues to highlight, but we really are talking about the EU today, the European Union, and not UK initiatives. And in particular, we're going to highlight two different pieces of legislation within that EU digital agenda, part of the EU's sweeping set of changes, and part, and I say part because it comprises a number of other initiatives like AI rules, like data governance rules, and more, but focusing in on the DSA, the Digital Services Act, and the DMA, the Digital Markets Act. Now, the DMA is an ex-ante competition law, really, only applying to the very large, and we'll talk about those thresholds and talk about how, in reality, there are only 15 to 20 businesses globally impacted by the DMA itself, although many who supply to or interact with those businesses regulated by DMA may feel some impact and may actually feel some benefit as the market changes. So maybe the DMA relevant, but less relevant to some dialing in and listening, but it's something that we need to understand. And then, of course, the Digital Services Act, a much more wide-ranging set of laws, onerous for the large, a tiered set of responsibilities. So some on the smaller side also going to be impacted in certain ways, and we're going to talk about how they're impacted, understand it, how to split out those burdens within the Digital Services Act, and to understand what burdens you may face as a business. And Richard, Andrea, and Annie are going to take those in turn and talk those through. But essentially, we're just trying to provide some overview, but then some what if and what about me, and some context to these rules. There's been a lot reported about what they are, but not a lot about what they mean, and we hope to bring a little bit more understanding and a bit more of a picture with some guidance. What we should say is we now have these laws published. You can actually see them in black and white. You can download them, but we're still in the early stages. They've been implemented, but there's more to come. We expect guidance, we expect more context and other information around the way these laws will be applied and implemented coming along the way. So we simply can't have all the answers right now, but we can really say now is the time to think about these rules, now is the time to prepare, but most importantly, I suspect, work out whether you need to prepare and what kind of impact the DMA or the DSA may have upon you, your practice, and your business. So with that early introduction, I am Mark Webber, and I'll be handing over to my colleague Andrea Ortega to start to dig into some of what I've been talking about. So thank you for joining us, and Andrea, over to you.
Yeah, thanks, Mark. So we're going to start with the DSA. And the DSA aims to address the use of the internet for harmful purposes, including the trade of illegal goods, services, and content online, or the manipulation of algorithmic systems to amplify the spread of misinformation. And it's worth noting that before the DSA, the e-commerce directive, which was adopted over 20 years ago, has been the main legal framework for the provision of the digital services in the EU. Much has changed, obviously, in 20 years, and the rules now in the DSA are meant to update and upgrade that regime. And so the DSA builds on the rules of the e-commerce directive. It amends and complements it and addresses the particular issues emerging around online intermediaries. Now, similarly to the GDPR, the DSA takes the form of a regulation, which means that the new rules will be applied uniformly throughout the EU. Now, however, as Mark was pointing out initially, note that some terms, and in particular the term illegal content, which is at the heart of the DSA, are not defined within the DSA itself. So the DSA refers to other laws, either at the EU or national level. So, for example, some terms such as terrorist content, child sexual abuse material, or illegal hate speech are defined at the EU level, but for some others, we'll have to rely on national legislation. In addition to that, the sanction mechanism combines enforcement at both the EU level by the European Commission and also at the member state level. So each member state will specify the penalties in their national laws in line with the requirements set out in the DSA. This is to say that while the DSA means more in terms of harmonization at the EU level, we'll have to see how it is interpreted and enforced in practice, considering both the EU and national levels. On the other hand, and also similarly to the GDPR, these rules will apply to all players, European and non-European players. So it has extraterritorial reach and applies to intermediary services offered to recipients of services where these recipients are established or located in the European Union. The rules primarily concern online intermediaries and platforms that transmit, store, or make available third-party content to EU-based users. So this includes online marketplaces, social media networks, content sharing platforms, app stores, messaging services, network infrastructure services, and also online search engines, among others. The DSA uses a progressive system under which the obligations become more onerous to match role, size, and impact on the online ecosystem. So in terms of size and impact, we have very large online platforms and very large search engines, which are subject to stricter obligations. And then on the other side of the spectrum, we have intermediary services that qualify as micro and small, which are exempt from most of the obligations. And even if you're a micro and small company, if you grow significantly, these companies will benefit from a targeted exemption from a set of obligations during a transitional 12-month period. Before we go into more details, in terms of timing to comply, the DSA will start applying in 2 steps. It will be directly applicable across the EU and to all service providers in scope on 17th February 2024. But for very large online platforms and very large search engines, which are directly supervised by the European Commission as regards to their systemic obligations, the new rules will kick in earlier following a designation process, and Annie will come back to this later on in the presentation. So moving ahead, as mentioned, the DSA applies to intermediary services, and we're going to go into a bit more detail about what this means and what types of services and providers are within this scope. It follows the same categorization in the Commerce Directive by defining intermediary services as one of the following information society services. First are mirror conduit services, second caching services, and finally hosting services. Mirror conduit refers to when the provider is a passive transmitter of information, so for example, email providers. Caching providers are providers that temporarily store information to make the exchange more efficient, so for instance, content delivery networks. And hosting services refer to the storage of information. In addition, the DSA distinguishes within the broader category of providers of hosting services the subcategory of online platforms. And online platforms are defined as providers of hosting services that not only store information, but also disseminate that information to the public at the request of the recipients of the services. So this is, for instance, social networks. And you have some examples for each of these categories in the slides. Now that we've explained quite quickly what services fall in scope, there's basically, in the tiered approach, there's basically 4 tiers of obligations. So tier 1 refers to obligations that apply to all intermediary services. Tier 2, which is highlighted in blue, refers to the additional obligations that apply to hosting services. Tier 3 refers to the subcategory of online platforms. And finally, Tier 4 refers to the additional obligations that apply to very large online platforms and very large search engines. And potentially the image on the slide is a bit more visual on those tiers. I'm going to start with Tier 1 and then hand over to the rest of the team to address the following tiers. For Tier 1, the basic obligations that apply to all intermediary services, which mainly aim to ensure transparency and fundamental rights protection, are firstly, cooperating with authorities. This includes in particular member state authorities and the European Commission. And this includes making public and keeping updated the information necessary to easily identify and communicate with the provider's single point of contact. Secondly, there's designating and making public a single point of contact for the recipients of the service. And for those providers which do not have an establishment in the EU, this also includes designating an EU legal representative. Thirdly, there's including in the terms of service information on any restrictions imposed in relation to the use of the service. And this includes, for instance, information on any policies, procedures, measures, and tools used for the purpose of content moderation, including algorithmic decision-making and human review, as well as the rules of procedure of the internal complaint handling system. And finally, all intermediary services shall make publicly available at least once a year a comprehensive report on any content moderation that they've engaged in. Now, importantly, and before we go into more details into the other tiers, the DSA preserves the liability exemptions for intermediary services that were introduced in the e-commerce directive with some clarifications. And different rules applied in view of the different nature of the activities and services provided. So for instance, mere conduit and caching service providers would not be liable for the information transmitted or accessed when they are in no way involved with information transmitted or accessed. So this requires, among other things, that the provider does not modify the information that it transmits or to which it provides access. In the case of hosting services, the provider should, for instance, upon obtaining actual knowledge or awareness of an illegal activity or illegal content, act expeditiously to remove it or to disable access to that content. And for the US audience, importantly, these liability exemptions would be equivalent to Section 230 of the Communications Decency Act, under which online intermediaries that host or republish speech are protected against a range of laws that might otherwise be used to hold them accountable and legally responsible for what others say and do. So that's it for Tier 1. Now we're going to jump into Tiers 2 and 3 with Richard, and Annie will address Tier 4 with the very large online platforms and very large search engines. So on to you, Richard.
Thanks, Andrea. So just to level set very quickly, Andrea has talked so far about the obligations that apply to all intermediary services, those services which are within scope of the DSA, whether they are mere conduits, whether they are caching services, or whether they are hosting services. And what you may have gathered so far is that actually it's a pretty limited set of obligations that apply at that Tier 1 level. Now we're going to start stepping things up and looking at the more onerous obligations. So I'm going to be talking about the Tier 2 and Tier 3 obligations, which apply to hosting services, that third large bracket of providers under the DSA, and a subcategory of a type of hosting service who are online platforms. To begin with, I think it's important to understand the distinction between these two types of service providers. It's important to understand this because there's such a broad range of services that fall within hosting. So understanding at what point they qualify and become an online platform is going to be quite key for this piece of law. So let's start with hosting services. So these are services that essentially merely store information at the user's request. So some obvious examples here might be cloud computing services or web hosting services. An online platform, it not only stores information at the request of the user, but it also disseminates that information to the public. And that's a defined phrase that's defined within the DSA. So some examples here would be social networks, online marketplaces, and other kind of services that enable users to share content and information. Let's dig in a little bit more to that definition of what constitutes disseminating information to the public. So the DSA says this is where the platform is making information easily and generally available to a potentially unlimited number of persons. So importantly, we're talking about information that is stored on the platform at the user's request. And at the user's request, the platform also makes that information available to the public. Helpfully, the DSA includes some examples. So for example, it says if the platform is providing interpersonal communication services, so for example, an email service or private messaging, that's not disseminating information to the public because they're just sending communications between a finite number of persons, and the sender, the user, is determining who's receiving those communications. So that wouldn't count as an online platform service. However, if that service allows users to post messages to a public group or send messages to an open channel where the sender hasn't determined the recipient, then that would fall within scope of being an online platform. Now, naturally, for a lot of modern services, things can get complicated because they might provide different features. They might include private messaging. They might include message boards and open forums. So it's going to be very important for service providers to identify which one of our services are pure hosting and which one of our services fall within that open platform definition. The DSA also addresses use cases where the service requires registration, so you have to create an account and log in. Does that still qualify as disseminating information to the public? And it says yes, it can do if that registration is automatic and it doesn't involve any kind of human decision or selection process. And I think what they're intending to capture there is if you can sign up for an account online easily and it's automatically you're in, but you have some credentials, then within that platform, you are still potentially disseminating information to the public. They also have an exception for services that are purely minor and ancillary features. So if there's an aspect of the service that does disseminate information to the public, but it's just minor and ancillary, that doesn't pull the service within scope of being an online platform. And hopefully they provide a couple of examples. So one is, well, the comment section in an online newspaper. They say that's probably an ancillary service because the online newspaper's main service is publishing news under their editorial responsibility. So the fact that they have a comment section doesn't necessarily mean they're within scope of being an online platform. By contrast, though, they say, okay, a social network that has a comments feature and allows people to post comments to other users, even though that comments feature might be ancillary to other services and features provided on the platform, that's more likely to be considered an online platform service. So as we said earlier, there's going to be more guidance and discussion around how the law is going to be interpreted, but understanding which services are within scope and whether they fall on the hosting or the platform side of things is going to be very important. So let's talk about the obligations. And on this slide, we've covered both Tier 2 and Tier 3. And as you can see immediately, for hosting services, There's only a couple of really additional obligations for hosting services on top of the ones that Andrea's already discussed. So the first is that in addition to the ones Andrea's mentioned, the hosting services need to implement a notice and action mechanism to remove online content that is distributed or stored on their service. So that means they have to give users mechanisms to notify them of illegal content that they're hosting, and they have to process those requests and notices in a timely, diligent, non-arbitrary and objective manner. And if they remove content from their service, they also have to provide the user who is storing and owning that content, they have to give them a reason why the content's being removed. There's another obligation too called out in the DSA, which is that if a hosting service is suspicious of any criminal offences that involve a threat to a person's life or safety, they have to report those suspicions to law enforcement and make available all relevant information. Moving on, now we're starting to consider the tier 3 obligations. So these are the ones that only apply to those online platforms. And as you can see, we're looking at a much longer list here, and things start to get more onerous for the online platform. So the first one that's specific to online platforms is that they have to provide a complaints and redress mechanism for their users. This involves a complaint handling system. So if they take down content from their platform, for 6 months following that takedown, they have to give users access to that system that allows them to issue a complaint, and then the complaint has to be handled by the platform in a timely, non-discriminatory, diligent, and non-arbitrary manner. In addition to that, users also should have the ability to settle disputes in an out-of-court dispute settlement mechanism as well. The next one for online platforms is how they deal with trusted flaggers, and this is a new concept under the DSA. So as part of the notice and action procedure, platforms also have to respond to notices from so-called trusted flaggers, and they have to deal with those notices preferentially and more rapidly than they deal with other kinds of notices. Now, we're not going to go into too much depth in who trusted flaggers are, but this is a distinct status that's going to be awarded to particular entities by the digital services coordinators appointed in each member state. So there is a whole structure and system to this. So that status can only be awarded to entities, not individuals. And these entities have to qualify, so they have to demonstrate certain expertise and competence in tackling illegal content. So we won't go into too much more on that subject, but suffice it to say, over the next year, we'll start to see who may be considered a trusted flagger and what role they might play. Moving on, there's also a number of other obligations for online platforms, and these start to stray away from that content moderation space. So now we're looking at other areas where we're thinking about what's fair for users online. One of those is around the use of recommendation systems on the platform. So platforms are expected to be a lot more transparent in their terms and conditions about how content is recommended to users through algorithms and why certain content is suggested. Oh, I think we just lost the slide deck. I'll just bring that back up. Here we go. Oh, back in, oh, pardon me. I'll just scroll down to the slide because for some reason it's being a little uncooperative. Okay. So where did I get to? Okay, so we've got recommendation systems, and then we can start talking about dark patterns. So this is a topic that's been discussed a lot in the last year or two, but particularly around in the privacy space and how dark patterns are used to influence users' choices with respect to cookies and other privacy choices. But the DSA is talking more broadly about the use of dark patterns in online interfaces, and effectively it prohibits those dark patterns where they deceive or manipulate users and impair their ability to make free and informed decisions. So that's quite broad, and it really requires the platform to scrutinize and interrogate all of their online interfaces that invite the user to make a particular choice, for instance, over their settings or whether to sign up to a new feature, etc. And then the last two on that list are all around advertising. So the first is that platforms have to be a lot more transparent in how advertising is presented to users and why certain advertising is presented. And then the second area is a little blunter. It's saying that platforms will no longer be able to target advertising to minors, children, and for the purposes of the DSA, that's if you're under 18 years of age. And the second ban is that you can't direct and target advertising to users based on profiling using special category data under the GDPR. And as a reminder, that's effectively sensitive forms of data like health, ethnicity, political views, etc. Under the DSA, you can't use that information to profile and target advertising to your users. So as you can see, there's a broad range of different obligations under the DSA, and these are pretty important. They cut across many different aspects of the business in terms of product, advertising, terms, etc. And there'll be a lot for platforms within scope to think about. And now I'm going to hand over to Annie, who's going to lead us into the final top tier of obligations that apply to the very large platforms. Annie, over to you.
Thanks, Richard. So as introduced by Richard, we're going to talk about Tier 4, which relates to very large online platforms and very large online search engines. Due to their incredible reach and influence, very large online platforms are placed under additional obligations to mitigate the risks they pose regarding the spread of illegal content online. The threshold of being deemed a very large online platform or search engine is met where a platform has more than 45 million active users per month on average within the EU. This number roughly represents 10% of EU consumers. Just to highlight that the designation is different under the DSA and the DMA, and in some ways the designation in the DSA is more straightforward as it is based only on this one threshold, whereas the DMA differentiates between business users and non-business users. The DSA does not, and it is a calculation of all active recipients of services. The methodology for calculating the average number of monthly users is unclear, but we expect the Commission to issue supplementary information containing a methodology to calculate that in due course. For now, what we do know is that it's a calculation based on those in the Union, and it is the average of monthly recipients of services over a 6-month period. Based on this, the European Commission will designate which entities are very large online platforms and search engines. This information is made available to it by providers of online platforms through their obligations to publish the number of active end users on their online interface. And online platforms have to do this by the 17th of February 2023. And the Commission can also use any other information available to them to designate online platforms as very large. So non-compliance with those obligations in the Act doesn't have the effect of avoiding designation. So very large online platforms and search engines will be published in the official journal of the European Union, and the list will be kept up to date by the Commission. Once designated as a very large online platform or search engine, they have 4 months to comply with their obligations under the DSA. So if we go on to the next slide. So in addition to the obligations that we have already heard from Richard and Andrea, these companies are subject to stringent due diligence requirements, which include things such as mandatory risk assessments and corresponding mitigation measures. They must conduct annual audits. They must appoint a compliance officer or function. They must, amongst other things, they need to set up a repository containing detailed advertising information, and this must be published. So going into the mandatory risk assessment, so when talking about this, we're referring to the analysis of systemic risks, which has a very broad definition, and it includes things like illegal content, human rights, political implications, and privacy violations. The obligation to mitigate relates to these risks. Very large online platforms must also undergo annual independent audits into their compliance with the DSA, and they must adopt recommendations from those audit reports within 1 month or justify the reasons for not doing so. In terms of a compliance officer, it must be independent from operational functions and it must report directly to management. Recommendation algorithms, so users must have a choice not to have recommendations based on profiling. And with regard to the repository of advertising data, so in addition to the obligations that Richard discussed, very large online platforms have to publish a repository of information relating to advertising, including the content of the advert, the person on whose behalf it was displayed, the period during which it was displayed on, and so on. Regarding data access, certain data must be made available to authorities, including data relating to compliance with the DSA. And platforms will be under supervision of the European Commission and the so-called digital services coordinators. So with that, I'll hand back over to Richard, and I think we're going to go on to the Digital Markets Act.
Yeah, thank you, Annie. So that was, I think it's fair to say, a whistle-stop tour of the DSA, and I don't think we have not covered all of the obligations or all aspects of the DSA. There are other ones, but we've covered basically the key things to be thinking about in terms of which providers are within scope, how services are defined, and what are the key obligations for those services. We'll come back to some more practical tips a little later, but before we do that, we're going to spend a few minutes talking about the DMA, the Digital Markets Act. So as Mark mentioned earlier, this is a separate piece of law to the DSA, and I think there has been a little bit of confusion in some discussions between these two different laws and what they're all about. The DMA is effectively a competition regulation. It's a set of ex-ante competition rules that are going to apply to the very largest platforms in the EU. And the term that's used is gatekeepers. So these so-called digital gatekeepers that provide a number of core platform services to both business users and end users in the European Union. What the regulation effectively does is it draws heavily on past competition cases that have been brought by the European Commission. And these rules are going to sit on top of existing competition rules, both at the EU and national level. So it's not replacing any existing rules, but it's going to complement those rules and sit on top of them. Very importantly, it's also going to introduce new enforcement powers for the European Commission, including a very large level of possible fines, up to 10% of the company's global turnover, quite eye-watering amounts when you think about the size of these companies. But the European Commission is also going to have a sweeping set of other enforcement powers, including the ability to enforce behavioral and structural remedies, and also to conduct market investigations as well. So this law is really seen as a very game-changing and important antitrust and anti-competition law. Let's just spend a couple of minutes talking about who these gatekeepers might be. So there's both a qualitative and quantitative assessment of who's within scope, and it gets quite technical. So on the left, here we're looking at the qualitative assessment. So we're talking about platform services that are provided in multiple EU member states and which have a significant impact on the EU market. There's a enumerated list of services that are within scope. That's an exhaustive list, and there are 10 which are covered by the regulation. They're listed at the bottom there. Even though there are only 10 within scope, you can see they're pretty broad actually, so it captures all kinds of services. But importantly, those services have to be provided in multiple EU states, and there has to be a significant impact for the EU market as well. The second threshold is very important. That's the fact that the platform is acting as a gateway both for business users and end users as well. So it provides services to both businesses and consumers. And the third feature is that this platform enjoys an entrenched and durable position in the market. So either whether it qualifies now as having an entrenched position, but also if that entrenched position is foreseen in the future as well. Now, in terms of who actually is going to meet that qualitative assessment, well, there are some presumptions built in. So if the platform is providing services in at least 3 EU member states, then that's one of the conditions satisfied. If it has an annual EU turnover of over 7.5 billion euros in the last 3 financial years, or an average market cap of over 75 billion euros in the last financial year, that's the second condition met. And then also they also have to have a certain amount of both end users and business users in the EU, 45 million for end users and 10,000 active business users in the EU. So as you can see, there's a fairly long list of criteria that need to be met, and the obligation and onus is on these companies to determine whether they fall within scope or not, and then if they think they do, to notify the European Commission. The European Commission can also carry out its own market investigations and determine on its own whether they think a company falls within scope. And importantly, even if a company does not meet these criteria, the European Commission has leverage to designate the companies within scope following its own market study as well. So these are pretty important powers that the Commission has. In practice, what does this mean? Well, we're looking at the big tech, and we're really thinking about the largest 15 to 20 firms that are operating in the EU, and some of the biggest names out there. So it's really a handful of companies, and many are not going to fall within scope. There's also a long lead time in terms of when the DMA is going to become effective and when the designation process is taking place. So I'll just hand back to Annie now, who's going to explain the timeline on that.
Thanks, Richard. So the DMA enters into force on the 1st of November, and it becomes fully applicable on the 2nd of May 2023. Following that, within 2 months of it becoming applicable, companies have to notify the Commission if they meet the quantitative thresholds to qualify as a gatekeeper. Once they have notified the Commission has 45 days to issue a gatekeeper designation decision. So the earliest we expect the timing for the first designation by the European Commission is summer 2023, and then the earliest expected timing for when the first designated gatekeepers will need to comply with the DMA, which is 6 months following the designation decision, would be around spring 2024.
And in terms of the obligations that apply to in-scope gatekeepers, so the DMA establishes do's and don'ts that gatekeepers must comply with in their daily operations, and some examples we've listed on the slide. So for the do's, we have allowing third parties to interoperate with the gatekeepers' own services in certain specific situations, allowing their business users to access the data that they generate in their use of the gatekeepers platform, providing companies advertising on their platform with the tools and information necessary for advertisers and publishers to carry out their own independent verification of their advertisements hosted by the gatekeeper, and allowing their business users to promote their offer and conclude contracts with their customers outside the gatekeeper's platform. And we wanted to highlight some of the data protection, so that the data protection perspective of some of these obligations. And for these first 4, some of these obligations are in line with the rights of data subjects to access their personal data and the right to data portability under the GDPR. So interestingly, in the case of the access right, in this context, this requires gatekeepers to provide business users with access to the usage data generated from their use of the core platform services. Examples of the don'ts include treating services and products offered by the gatekeeper itself more favorably in ranking than similar services or products offered by third parties on the gatekeeper's platform. So that's to the point of self-preferencing, preventing consumers from linking up to businesses outside their platforms, preventing users from uninstalling any pre-installed software or app if they wish so, and tracking end users outside of the gatekeeper's core platform service for the purposes of targeted advertising without effective consent having been granted. So to the data protection aspects, in this case, gatekeepers will need to obtain consent for a few things. So to combine personal data from a core platform service with personal data from other services, combining personal data from the core platform service with third-party data. So for example, data collected from third-party websites via cookies, also for processing third-party data for advertising purposes, and finally, for signing in end users to multiple services offered by the gatekeeper in order to combine personal data. It's worth noting as well that to ensure that the new gatekeeper rules keep up with the fast pace of digital markets, the European Commission will carry out market investigations and update dynamically the obligations for gatekeepers when necessary. So this will be quite challenging, and we'll have to see how it plays out. And I'm moving on to Richard, who's going to address some practical takeaways for both the DSA and the DMA.
Yeah, absolutely. Thanks, Andrea. So far, we have thrown a lot of law at you, and there is a huge amount to cover. It's a lot to cover in this webinar, and even when you go into more depth, there's a huge complexity and range to these laws, and there's a lot to learn. So I think at this point, it's probably a good moment to break down some of the practical things you need to start thinking about when it comes to the DSA and the DMA. And how you're going to approach these two laws for your company. The first thing is don't panic. It probably feels a little bit overwhelming, and trying to navigate these laws might seem like a very dense forest, but there is a way to approach it. So firstly, it's important to identify whether the DSA and or the DMA actually apply to you. And probably what you've gathered, you might have a good sense of whether the DMA is even going to be relevant. For most, it's not going to be directly applicable to you because, as we've said, that's only going to apply to the very large platforms. But still worth thinking about if you think you might be on the fringe of some of those criteria. By contrast, the DSA is likely to apply to a very broad range of services, and it captures most. But you need to then think about, well, which services are within scope and which definitions do we need to be thinking about? And that's really important because, as we've seen, for most, there are actually fairly limited obligations under the DSA, whereas when we start to think about certain types of services, those commitments and obligations start to grow and build, and that's when you're starting to think about the more onerous requirements of the DSA. So identify whether you're within scope of the laws, and also identify which services are within scope. That might become a little bit more complicated if you're offering different products, different services, because let's not forget, under the DSA, we're thinking about requirements that apply for particular services. And the regulation actually calls that out and says that a single provider might provide certain services that are within scope of certain rules and other services that are within scope of other rules. So navigating that and identifying the boundaries is going to be really key. Lastly, also, if you think you might qualify as one of those very large online platforms or search engines under the DSA, then you have to think about, well, what's the methodology that we're going to use to calculate our monthly active user base for each of our services to identify whether we are potentially within scope of those most onerous rules. So step one is that scoping exercise, very important. The second step will be, okay, we know which aspects of the law apply to us. So let's start mapping out the relevant requirements and identify which requirements apply to us and which service. So for example, online services, generally they need to be thinking about the liability regime under the DSA and how they're dealing with illegal content on their service and how they are complying with those notice and takedown requirements. Then stepping up, if you actually qualify as a hosting service, you'll also need to think about those additional obligations around providing notice and action mechanisms for users. And then if you have services that qualify as an online platform, you'll need to think about all of those additional obligations as well, including providing a complaints mechanism for your users and addressing the other range of requirements that are specified under the DSA. In terms of timing, don't forget the deadlines. So the DSA for most comes into effect on 17th of February 2024. So you do have time, but there's a lot to think about. And then the last step, okay, we know what we need to achieve, but how do we get there? So it's all about translating those legal requirements into concrete actions. And importantly, also start thinking about who you need to engage within the business, who are the internal stakeholders that are going to need to be involved. So for instance, for some, this might be thinking about, okay, we need to update our terms and conditions to address informational and transparency requirements. In particular, how are we addressing content moderation through our service? For others, depending on which requirements apply, you might need to be thinking about your online interfaces. Are there any potential dark patterns that we need to think about? And also, how do we address transparency requirements within online interfaces? And also, for some, you'll also need to think about internal complaints processes and setting that up. So given the broad scope of a law like the DSA, you will need to engage with different parts of the business. That could be the legal and commercial team, it could be the product team, it could be content moderation, it could be advertising. Identifying, how are we going to tackle this and who needs to be involved is going to be a really important thing to think about. So breaking down this into stages will help you address what is otherwise quite a complex piece of regulation. And don't forget, don't panic, there is time, and there are people who can help, including Fieldfisher. So everyone who's presented today, Mark, myself, Andrea, Annie, we are very happy to help if you have follow-up questions from this webinar today.
Yeah, and thanks very much, Richard. And we should also say it may be direct here from Silicon Valley, but also reaching into some of our fantastic colleagues in Europe and France, and particularly our Belgian office that have also building a centre of excellence around a lot of this digital agenda. So thank you for joining us today. News of what's coming ahead with the Fieldfisher webinars, looking ahead to the 7th of December. So after Thanksgiving, for those of us out in the US, we're going to have a session on data privacy, looking ahead for 2023. Looking at predictions, what we need to think about, maybe what we need to prepare some budget for, what we need to allocate some resource for, and just looking at this multitude of almost tidal wave of new things that are potentially coming. And of course, there's the things that we know that are going to happen, and then there's those old faithfuls. Every 6 months we speculate about e-privacy. Maybe we really will see an AI Act. Maybe we will see new developments in US state law. So just looking a little bit ahead with some of our predictions about what we think you're going to be working on and what we think we're going to be preparing for 2023. So myself, Eilish, hopefully a number of our colleagues will be joining you for that. So details to follow, looking up. If you'd like to be on our lists, please let us know. And we will be recording this, making a copy available, and undoubtedly popping it out on LinkedIn, putting it on our YouTube channel, but it will always be available within 24 or 48 hours if you just want to contact your usual Fieldfisher contact. Thanks very much.